It's not uncommon for people to be uncomfortable talking about death or when the time may come when we may be unable to make decisions on our own. Do I really need estate planning? Yes, of course. Estate planning is for everyone. Single people, single with children, married, with or without children, families with members who have special needs, and even parents of fur babies. Estate planning allows you to name the people you want to receive the things you own after you die, take care of your finances if you can't while you're still alive, including caring for minor children, and minimizing taxes, court costs, and unnecessary legal fees. Don't you need to be rich or have a lot of money for estate planning? No, not at all. Your estate includes everything you own: furniture, personal belongings, your checking and savings accounts, life insurance policies, cars, homes, and any other investments you may have. Big or small, estate planning covers it all. Remember, we all have an estate. And if you don't have a plan, your state will create a plan for you. So create a plan to protect your assets and your family while you can. Thank you everyone for joining us. My name is Leatrice Moore. I'm the Executive Director with the Black Community Developers Group. We are hosting this workshop in conjunction with the Association of Black Estate Planning Professionals. And I'd like to introduce Aimee Griffin. She is the president and chair of the Association of Black Estate Planning, and she's been recognized for her leadership, her business and legal acumen, and Aimee serves with her voice to support economic development. So welcome, Aimee, and you got the floor.
Thank you, thank you, thank you. Now, we are excited that this is Estate Planning Awareness Month. And so what we realize, and we're excited to operate in conjunction with the Black Community Developers Group, which is one of the 15 strategic partners of the Association of Black Estate Planning Professionals. It's the Association of Black Estate Planning Professionals, not just about the estate plan, it's about the economic total picture. And so therefore we have 15 strategic partners with which we work. But what we do know is that for Black people, typically, our real property is one of the greatest assets. And so we are very thoughtful about how do we need to be moving forward to protect those assets. So we build together and then we are able to bridge the racial wealth gap, which is the mission of the Association of Black Estate Planning Professionals. I'm excited that we are here today to have a chat about how do we strategically build that racial wealth gap or build our net worth. And one of the ways in which we do that is through estate planning. I am excited that we have a number of amazing legal practitioners who will celebrate with us estate planning. I'm going to just talk I want to invite you to go to their websites because these are phenomenal folks who will be sharing with us today, and I get to moderate. Chioma Deere is a Florida licensed attorney and the owner of the Deere Law Firm in West Palm Beach, Florida. Chioma is a technology certified lawyer with a background in civil litigation. In her law firm, Chioma helps clients with customized solutions in the areas of estate planning, trust, wills, probate, and Medicaid asset protection while using the power of technology. And she, again, is in Florida. Jennifer Norton, our mid-state person, was born and raised in Indianapolis, Indiana. As a proud 2001 graduate of Cathedral High School, a school that prides itself on academics excellence, faith, and service, Jennifer then attended Indiana University Bloomington to obtain a Bachelor of Science degree in finance. From there, entered the Maurer School of Law, formerly Indiana University School of Law, Bloomington. Since graduating in 2008, she's confined her practice to the areas of estate planning. In 2009, she became a member of the National Network of Estate Planning Attorneys, uncovering her passion and gained substance legal training in estate and tax planning. Charlene Usher, now going to the left part of the country, As the founder of the Usher Law Group, Charlene Usher holds the highest standard of client service, scholarship, and lawyer accessibility. She was admitted to the California Bar in 1997. She's a graduate of California State Polytechnic, University of Pomona, University of California Hastings College of Law. Ms. Usher is also admitted to practice before the United States Court of Appeal for the Ninth Circuit, the California Supreme Court, and the United States Supreme Court. Now, this gentleman I'm about to introduce is named Andrew Griffin. He is truly one of my heroes because he's my older brother. He's a licensed California attorney who's been licensed since 1983. Woo! Mr. Griffin is a real estate broker licensed by the state of California since 1999. He's bilingual, fluent in Spanish and English languages. Since establishing the law offices of Andrew H. Griffin, APC, the third APC, and he assisted thousands of clients in effectively navigating the legal process to protect and retain real estate. He earned his Juris Doctorate degree from Thomas Jefferson School of Law in San Diego. He serves as an adjunct law professor at Thomas, where he teaches trust and estates in California community property. So we have covered the state or the nation, and we want to make sure that we had people who have really they don't just dabble in estate planning, they serve estate planning. So if you don't check those folks out, please check out their bios for real, because we are to have a little bit of time today, but we're going to touch on a few topics, and we're going to make this a conversation, right? And so we're going to start off by asking a simple question: why estate planning, right? And we're going to start with Charlene, because you're right there on my screen. Why estate planning? Why do you do this?
Okay, thank you so much for having me. I know it was sort of short notice, but I was glad I was able to squeeze it in. I love this topic. I am an estate planning attorney here in Southern California. I actually cover the state, and we also do probate and trust administration, no litigation if we can avoid it. Why estate planning? Why estate planning is because we all have an estate. You actually all have a plan. If you haven't made your own plan, you have what I call the California default plan. The law in California has a plan for your assets if you pass away and you have not made your own plan. So the reason why you want to do your own plan is because you control all the factors. You can keep your information private. Nobody has to know what all your assets are and who all your family is. You can make sure that you decide what happens to your assets and how they're transferred. Are your children going to get everything outright when they turn 18, or are they going to get it over time? Something happens to you. You can make sure that you save tens of thousands of dollars in probate costs. I do probate law, and probate attorneys are happy to take the money from all these families who leave nothing behind as far as documents and the proper estate plan. And they been getting paid for decades, and particularly from our community. So I'm so excited that you all are here, and I hope that your ears open to hear from all of us, because we're here to make sure that you are educated, informed, and ready to take action.
Absolutely. Jennifer, jump in there.
So why estate planning? So I've always prided myself on getting on areas where I cannot be eliminated. So hence finance, someone's always got to count the money. And then I naturally led into estate planning because we all can't live here forever. I guess my biggest passion is that, especially as African-Americans, Black and brown, yellow people, we have the highest discretionary income in this country, but we have nothing to show for it. When the first death occurs, the first generation, it spends about 70% of the inheritance, and the second generation depletes about 90% of it. And so my passion has always been centered around my community. In working with the National Network of Estate Planning Attorneys, I worked for the CEO for about 4.5 years, and he had about 270 something client families in his practice, and only a handful of the clients were of any ethnicity outside of the majority race, which motivated me to start my own practice. And so since then, for the last 8.5 years, I've been practicing 13 years. For the last 8.5 years, I've confined myself mainly to trust-based estate planning, just so that that wealth can move from one generation to the next. I do all of the others, but the goal is to essentially be proactive, foster family harmony, because we know what happens with death and money and how the fights all break out. And so my goal and my passion is dedicated to my community, preserving our wealth, and then changing the trajectory of our family lineages.
I'm going to switch this up a little on Chioma by asking you, for those people who say, I don't have enough to plan for us to have an estate plan, what is your response to that?
Well, for me, it's more than just what is enough. Enough is relative, I think. And like the other women that have talked this afternoon, Charlene and Jennifer, I really appreciate what has been said so far. Having enough is relative, right? Because you can grow wealth. And like we're talking about, just like in California and Florida, if you don't have a plan, the state has a plan for you, but it's not to grow your wealth. And definitely making sure that you start something, no matter what it might be. I think people have this false myth in their head that estate planning is only for the wealthy. The wealthy plan for your money is really what I tell people who ask me about estate planning as well. And people must understand that wealth is accumulated by making wise decisions, right? About money, people, opportunities, as well as things. So by making sure that you're accounting for everything, it doesn't mean that you have to be what is considered conventionally wealthy in order to take care of your estate planning and making sure that you have a plan in place.
Drew, affectionately referred to. Drew, so what do you say to those people who say, that why should we continue to plan because we're going to continue to end up in the same way? What do you say to those folks, especially having a real estate focus? How do you say that? How do you manage that? You're on mute, Drew.
No matter how old you are, you still have to figure out how to work these machines. And now that I've gotten the unmute bar, I can let you know that it's interesting that no matter what you think, you're talking about your family, and you know that as we have children, we spend our fortunes, and having children. And when you talk about those fortunes, you also want to talk about the generational wealth. And if you're trying to pass it on to the next generation, then you need to think about what are you doing now? And you could say, okay, I don't have this money. But yes, you have it because you have a generation that you have to take care of, let the next generation go on. You want to continue on. And that's one of the things that we, especially as minorities, have to talk about is at the dinner table is what we do as a generation to keep that wealth passing by. So if you're asking the question, is it worthwhile to do this? It's absolutely worthwhile to do it.
Okay. So, Jennifer, what's a power of attorney?
So great question. A power of attorney basically is a document that lays out in the event that you can't make your own financial, there's two types of powers of attorney. There's a healthcare and a financial. But in the event that you couldn't make your own financial decisions, it's important that you secure a financial power of attorney so that you can nominate who you want to make those decisions on your behalf. A lot of married people, unfortunately, think and rely on their marriage as the solution to a lot of things, saying, oh, I'm married, my spouse can get access. But if you want to take a test and, you want to go on this nice little adventure, try calling your spouse's retirement, carrier and provider, and see if you can get through just because you're the spouse. You'll find that you will be denied access. Same thing goes if you decide to contact any government agency to access any financial information on behalf of your spouse, let alone any other loved one. They're going to require a financial power of attorney. So you're going to want to get that document to nominate the person or persons that you would like to act on your behalf. And then you want to make sure you always have succession. So especially if your spouses, if you're in a common accident, you want to make sure that you have that succession there, so that you have someone else that can be called up to serve. Did you want me to do healthcare too, or just stick with finance?
Nope. Charlene, talk to me about what's a fiduciary.
A fiduciary is someone that's going to be appointed to be in charge of your things. I wanted to tag onto what Jennifer had to say about the power of attorney, because in these modern times, we have modern actions, right? So a lot of people are married and they are together and they're saying, we don't know if we want to commingle everything because, before I came here, I had some things and you had some things, and I want to keep my separate accounts, and maybe we'll have some joint accounts. And these are where these things show up. Whatever your separate accounts are, your marriage is not going to, that relationship is not going to take care of things when you need to have it. A lot of times I get phone calls from people saying they want to get a power of attorney for their parent. I don't know if anybody else has this issue. They call and get a power of attorney for their parent, and we're saying, why isn't the parent calling us? Are you just helping the parent find an attorney, or are you trying to get a power of attorney because someone's asking you for it and they cannot execute one? So you can only give away a power that is your power to grant. I cannot grant power for my mom or my daughter or my sister. I can only grant my own power, and I can only do so while I have capacity. So sometimes a medical situation has happened, and now a person has to leave the hospital and go to a rehabilitation facility. And guess what they want to know? How are we going to get paid? We would love to help your loved one, but the first thing we need to know is how are we going to get paid? Is it Medicare? Is it their account? Whatever it is, someone has to sign off for that. If the patient can't do it, you need to have a power of attorney. And that's why they're calling our office, because someone's asking them for a power of attorney and they cannot get one at that point. It's too late. So I just wanted to add that.
Absolutely. So Chioma, Jennifer spoke. Folks moved around on my calendar. Chioma, can you speak to sort of what is the fiduciary standard, right? How is that different?
It's different because you're held to a higher standard as a fiduciary, and a fiduciary is the person in Florida. It's the agent or the attorney in fact for the power of attorney, or it's the agent for the healthcare surrogate. You're held at a higher standard because you are being provided or put in charge of funds, bank accounts. You're allowed to make litigation decisions, settlements of things. You are in charge of people's money and how they get that money. And because of that, you're kind of like, I try to compare it to a banker. You're giving a banker their money. If they run away with it and go on a cruise, they can get in real trouble, right? It's the same thing for the mom who gives the power of attorney to the daughter. That daughter has that same high level of accountability to government agencies, to the police, and to the person that they are supposed to be taking care of and helping, because it's not their stuff. They may have the authority over it, but that authority can be revoked and that authority can be violated. And there are statutes and laws that govern all of that. So it is a much higher standard that you are held to. So when I counsel people about handing over that authority, as well as to the person who may be signing that acceptance of agent document, they need to understand that this is a serious thing that you're taking over. It's not just so that your mom can go into their rehab facility. All the actions that you take under this authority is you're accountable for, and you may have to go to court to testify about, kind of thing. So I want to make sure that people understand that that is something that should be taken very seriously.
Actually, I'm going to have Drew expand about, because one of my favorite stories about Drew is when you told the story about a son who was exploiting the mother financially. So can you talk a bit about when you see that, suspect that, what are the considerations or options?
Yeah, when I heard previous attorney talk about, the daughter calls for the mother, and you guys start talking about whether that there's dementia there, whether they have capacity to actually even sign that power of attorney. And I'm sorry, the reason why I was late coming here is because they had that exact same thing, a client in the other room, exact same thing. You always have to be careful about who it is that's telling you these stories, who it is that's going to be saying, oh, I need this for this and such. And all of a sudden you find out that things are not what they're supposed to be. And I was just recounting to him about a jockey who came to my office about 10 years ago who was like 4'2", and he was just the most engaging person. He was just telling us stories about being a jockey, how he fell off the horse and how he won and everything else. He was just engaging guy. He was just such a cute little guy, right? And then I did the trust for him. He died, like as we all may have a tendency to do. And I get sued. I get sued because they say that he did not have the capacity to prepare this trust. Now, all I know is this guy who tells a great joke and he's just entertaining and everything else like that. But they come back later on with medical records to show this guy didn't have the capacity to even, and he was disabled, getting disability. So we all have to be careful of that, not only from our family, our children, or whatever, but we have to be, as attorneys, we got to be careful, but we don't know who has the capacity out there. So, and that's one thing that, whether or not you have that fiduciary duty, whether you're acting on behalf of somebody who you might get in trouble because they're saying, oh, who's told you that she could sign this power of attorney? Who told you that they could make those rational decisions, even choosing you as that power of attorney? And those things are something that not only as the attorney, but also the person who has that power of attorney has to be careful about.
And so, Charlene, I'm going to jump to you to say, when someone does not have capacity to appoint someone as a power of attorney, what do you do?
Did you ask me that question?
Yes.
Okay, great. Well, what happens is if someone cannot execute a power because they've already lost capacity, then their family or whoever is going to have to go into probate court here in California and seek conservatorship. Either conservatorship of the person, which is their medical and living situation, or conservatorship of their estate, which is their financial and legal affairs, sometimes both. Unfortunately, in my experience, which is about 20 years, I see disparate treatment in probate court, depending on what family is showing up to seek conservatorship. And when they're brown and Black families, the perception is that they're out to do somebody in, or they're not sophisticated enough, and it's just an automatic, we need to go to our alternative. Our alternative is this fiduciary industry where people have a caseload and that's their job to conserve people, and they get paid to do that. And a lot of times these are cronies with the judges. I'm like, oh, you guys are talking about fishing before we start court. You guys are buddy. And then I see us, and it could be a professional looking person that looks like us, you or me, showing up, and that this treatment is different. And then hillbilly other person shows up, and they're saying, oh, you need 4 more months to provide a bank statement or whatever document. They just give them all kind of excuses, and they just let them because it's perception. And so I don't think that anybody wants to be subject to a judge who has never met you, know anything about you, making a quick decision because they have so many cases they have to address. They give 5 minutes to these decisions, and they're looking out there, and basically they just go off what they always do. That's what I see when I'm in court. So unfortunately, that's a reality that can be avoided by just having your documents in order.
Absolutely.
Aimee,
ahead.
can I just
Yes.
jump in? We have a lot of questions and some conversation going on in the chat, which is really good. But I wanted to, before we moved past it, kind of see if we can get some of those answered. So
Well, actually, I've been seeing that some of the attorneys have been answering the questions as they've been presented. So
can we get it on recording for those who may not be able to see it?
Oh,
So the question
absolutely.
is the fiduciary the title of the person who has power of attorney?
Okay, and so Charlene answered, in California, the power of attorney agent is called the attorney in fact. And Jennifer added that the fiduciary is a standard to which the agent or the person appointed to has to abide to. It's one of the highest duties under the law, and it's very similar to financial advisors. You can go to jail for misusing money or inappropriately using the funds. And then Chioma added, the most basic duty of the fiduciary is the duty of loyalty, which obligates the fiduciary to put the interests of the beneficiary first, ahead of the fiduciary's self-interest, and to refrain from exploiting the relationships for the fiduciary's personal benefit.
Perfect. And then another question was, does this title expire upon death, or is it like the executor of an estate? Great question.
A very good question. And Chioma replied that the power of attorney dies when the person dies, as did Jennifer. One of the things that when we talk about a power of attorney, it is that you get to represent the person, but if the person isn't here anymore, you no longer can represent them, as well as the person can no longer revoke that authority. So therefore, they're unable to that position no longer serves. But those are great questions, and that's one of the huge reasons why an estate plan is so important. And only 30% of Black people have an estate plan, which means that, unfortunately, as Charlene identified, those professional people jump in to serve and get paid and deplete the estate of a person who is disabled, because they can get paid for every time they blow their nose at the wrong time, right? So we are very thoughtful about. One of the reasons why we are able to be thoughtful about the strategic planning ahead of time, I think Charlene identified, there's a default if you don't plan, right? And so the foundational documents that people have in estate planning is, we talked about the power of attorney, which is foremost the management of your finances. And then let's talk a bit about the advanced healthcare directives. Who was it? Jennifer, can you talk about advanced healthcare directives?
Yes, most certainly. So advanced healthcare directives, similar to a power of attorney, are used in order to, one, appoint the person whom you wish to make your healthcare decisions on your behalf in the event that you couldn't do so for yourself. Some states like Indiana, we just moved to advanced healthcare directives. We used to have it segregated, where we have a healthcare power of attorney, a HIPAA, which is an authorization to disclose, which allows the hospital to speak to your named agent, as well as your living will. You're alive, but not so well. Do you want to be prolonged with artificial nutrition and hydration? So a living will, not a last will, is the one that addresses the healthcare aspect. Some states will combine all three of those documents in those roles and have it under the umbrella of the title Advanced Healthcare Directives. Just similar, like I said, similar to a financial power of attorney, with your Advanced Healthcare Directives, what you're doing is you're laying out who can do what. Now, the thing that in our practice, what I find is with a healthcare power of attorney, it basically, or advanced healthcare directive, it allows the person to do anything. You can sign me into a nursing home, sign me into a hospital, or sign a contract to have someone come out to my house. But it doesn't really say your preferences. So one of the biggest things that are challenges, goals, opportunities that I like to present to my clients is, yes, it's all well and good to have the documents, but it's just a document. The more important thing is to have a conversation. And so to help support our conversations in our practice, we have some checklists that help you kind of have conversations and document, how do you feel about choice of physicians, medications, institutionalized care? How often does your agent need to come see you? How close do you need to be to family? As well as your living will. if you are completely brain dead, do you want to be prolonged with artificial resuscitation, blood transfusions, things that will not lengthen your life, but of course they do lengthen the pockets, deepen the pockets of your doctors. And so it's very important to have those legal documents for your advanced healthcare needs, because just like married people under a financial power of attorney, they rely on their spouses. Some states, you cannot rely on your spouse. Indiana is in a unique state where we do have it statutorily in the law about priority, who is first. But if there is a disagreement, or if a doctor has gotten burned because they went by priority, and lo and behold, you and your wife are separated for the last 15 years, which does happen in our community where people marry but don't divorce because I like his pension, I want his, all kinds of stuff for financial reasons, we don't get divorces. But then you go and there's a hospital need or an emergency need, a health need, and the wrong person is stepping forward because of priority in the statute. Doctors will inevitably say, hey, go to court for what Attorney Usher was talking about, either a conservatorship, or in Indiana, we just call them guardianships, but for the same thing, person and estate. And so it's much, much more proactive to get those legal documents in place, because in Indiana, powers of attorney trump a guardianship. You only have to get a guardianship if you already have a power of attorney, if you're trying to forcibly commit someone to a mental or psychiatric facility. Do they require us to get a guardianship? You can't just do that alone on a power of attorney. So those those advanced healthcare directives, regardless of what your state calls them, are very key, but the conversations is even more important. A lot of attorneys would rather have an educated family sometimes that are on the same page than a document with everybody's running around clueless and making the wrong decisions. But why not have both? And so that's where we would prefer you guys to be, is to have your advanced healthcare directives and then have the conversation.
One of the things that I meant to talk about ask about, and I don't know if somebody, one of the attorneys can jump in about that, is supported decision-making for people with special needs. I don't know if anybody has had that experience, but supported decision-making. Jennifer, I see you nodding. You want to jump in?
Yeah, so what happens in Indiana is we can't just give away someone's complete independence. And that's what guardianships and conservatorships do, is if you don't have these supported decision-making options, which is essentially allows a person, how you have like high functioning person with autism, or a high functioning adult that has some other disability, but they can do this thing very well, but they need help on this thing. Well, in Indiana and in certain states, what you can do is instead of just ripping all of the control, all of the independence from the person, you can enter into these agreements on how a person can participate in their own decision-making, even though they technically do have a disability and maybe receiving governmental benefits. So for instance, we've had people be able to participate in some of their banking or some of their healthcare decisions, because they can process some of those decisions. But if it gets too highly technical or highly complex, then they have this other person that can support the decision, or be the last say on what course of treatment we're going to use if it's just a little bit above their ability to process. But supportive decision-making is required. We have to go through those steps in Indiana to say that if we're trying to take away someone's complete control, we have to say there was no other alternate setup that we can, or combination of a team that we could prepare to take away all their control.
So we talked about powers of attorney. We talked about healthcare directives. Now, the third leg of the foundational plan is a will. And so one of the things that we think that you're right, a will, you go to a lawyer's office, they read the will, and they think that's it because of TV. Attorney Usher, talk to us about what is probate. And probate being, we know that it is different for the different states, but talk about California probate.
Well, I consider probate in California to be a lawsuit against your family. So a probate scenario is where you haven't put any documents in place or not the proper documents. And now the court or the law in your state requires you to go through a legal process to ultimately get your assets to your legal heirs. Your legal heirs could be different from the people you would have chosen as your beneficiaries, but the law says who your heirs are when you have a probate. The reason why I talk about a lawsuit against your family is because a lot of times the attorney and the law firm takes more money than anybody else in the probate because that's the way the legal fees are set up, and they become an unintended heir of your estate. The administration fees for probate, meaning the cost for legal fees and filing fees, those come out first. And then any creditor claims come out, and then whatever's left over gets distributed to your family. So literally tens of thousands of dollars. Someone with $1 million estate is looking at $23,000 to $46,000, almost $50,000 in fees outset. That's the beginning minimum point for $1 million estate. A lot of people hear that number, they go, oh, that's just so much. I don't have $1 million. Well, in California, if you have real property, you probably do have $1 million in a state. Your real property, your bank accounts, your car, everything in your name is added up to figure out whether or not you have to go through a probate or your family goes through a probate process. So I will say people, when I have this conversation, their attitude is kind of like, I don't want to think about it. I don't want to talk about it. It will take care of itself when I'm not here. It's not my problem. I won't be here until I show them what their plan looks like. I think you care about that 50 grand. I think you would prefer that that 50 grand go to your loved one, your children, your grandchildren, your causes, your sorority, whatever is important to you, versus legal fees, versus a minimum 2-year process, versus the whole world knowing all your business because probate is public. At least here in California, you can just go look up a case, find out all the addresses, all the names, all the property, and start harassing people. That's what happens here in California. So the probate to me is to be avoided at all costs because all it is it leads to court, costs, and conflict, versus having an estate plan that's been carefully, thoughtfully put together that helps you transfer your assets outside the probate process, save money, and get it expedited. I have one more nugget to share, and it reminds me of when I was in law school. I met people in law school from all walks of life, not a whole lot of us, but I did meet a lot of different people. My Jewish friends had trusts. We were in our 20s. They had an apartment and a car. They didn't have any assets. You have a trust, and we talked about this in my wills and trust class. That's why I know about it. They have a trust because their community has been on this game for decades. They expect to receive assets transferred from parents and grandparents. In fact, that's what's paying for them to be in law school, why they're not in the financial aid line like the rest of us, because assets have been grown, assets have been cultivated. They're not spending a dime they don't have to, and they're not going in probate. So when I go in probate court, I rarely see a Jewish family in probate court in California. So I'm just going to say that.
Okay. Chioma, can you talk to us a bit more about trust? Understanding trust.
Sure. I wanted to add one more thing to what Charlene said. Because as you know, so many people come down to Florida to die. There's a lot of, not necessarily older people either, but we deal with a lot of that, and there are a lot of issues from elder law and trust and wills and so on. One of the things that I find in our community that isn't stressed enough, maybe they don't understand it enough, is that just because you have a will, and in Florida, a will governs everything that you own at the time of your death, but just because you have that will, you can't literally, once that person died, wave it around and magically deeds starting to transfer, cars get transferred, somewhere nothing happens with a will until you probate it. As long as there are assets in that estate, that will must go through probate. Just like if you didn't have a will. It doesn't mean that the exact same thing is going to happen, but it does involve court. It does involve sometimes litigation, and it can take a long time because you chose to put everything in a will versus a trust. Oh, and the common one in Florida is a revocable living trust. There are many other types of trusts other than a revocable living trust, but the revocable living trust is the common one because it has as its foundation probate avoidance. The important thing about a revocable living trust is you have to fund it, or else it's just a really expensive piece of paper for some people. The trust needs to either own or become the owner at the time of your death, those assets that you want to transfer or hold or grow, however you want that to happen. That revocable living trust is an agreement. It's not a testamentary document. It's an agreement between you, yourself often, and maybe someone else, but maybe yourself again. So it's the grantor. And in Florida, it's the grantor, the trustee, and the beneficiary. Those three people control a revocable living trust, and it's usually business as usual once you put everything into that trust. It's funded properly, then you'll know that you can avoid probate. But in the same way that a will doesn't magically do things once you pass away, a trust doesn't magically do things once you pass away either. It does require you to do some things, but you won't have to go through the prolonged, expensive process of probate.
Drew, talk about preserving real property through the estate planning process.
First of all, I want to say that I jump in. Everybody has the little. 38 years ago, when I became an attorney, my professor at law, he was a Black judge, and he told me, "I want you to do this favor for me." And I said, "What's that?" He says, "I want you to do your wills for free." And I said, "What?" He says, "I want you to do your wills for free, and you will have a retirement." You will have a retirement.
Wow.
So I didn't understand what he meant. And so now I have 4 file cabinets, 4 black file cabinets, 4 drawers with free wills. Understanding what was just been said, that the attorneys and the executors or administrators, they're going to make out much better many times than if they would have done, without a doubt, if they had done a trust, it would have been they would have been a lot better off had they done the trust as opposed to the will. So in the reality is, people think, okay, well, you know what? I have a property and it's I'm going to put my son's name on it, and along with my name. And Amy was telling you about this one case that I had. Well, yeah, the son went to the wife, mom, and said, "Mom, you're gonna die, and if you die, what's gonna happen to the property? I think you should put my name on it." Well, the son didn't really explain to the mom that I'm taking your name off as well. So now the son had the property, but the mom got the benefits of paying for the mortgage, paying for the taxes, paying for the insurance. And we end up having to file a lawsuit because we realized that the son would not give the property back. The other issues are, people will say, "Oh, you know what? I can just put it in joint tenancy." Okay, joint tenancy, that means if one person dies and it goes to the surviving spouse or the surviving joint tenant. Oh, what happens if both of you guys die together? You take trips together. You could die in the same airplane. You could die in the same car. What about if you get a divorce or something like that? You always have to understand that even if you have a real estate, and you're trying to figure out, okay, I'm gonna do estate planning by having a title in tenants in common or something to that effect. What you're doing still is not providing for something that happens upon your death. And many times if you have your son on the property and all of a sudden, oh boy, he gets in a car accident. Oh boy, he doesn't pay child support. Oh boy, he gets in a lawsuit. And now they put a lien on your property.
Mhm.
That's not what you wanted. You wanted, and something happens to me, I wanted to go to my son. Now his behavior is calling as a repercussion on you and your property. And all of a sudden, maybe that property is gone because somebody has liened that property. So be careful about people thinking that, oh, real estate is going to act as a replacement for a good estate planning, because it isn't. The best way to have real estate for estate planning is to make sure the title is under the name of the trust.
Can I add to that?
Yes.
I would like to say that because I do probate throughout the state of California, from Sacramento to San Diego, and all those counties, it informs my estate planning. So I see all the issues that happen when people either do nothing or try to do it themselves because everybody wants to save money. They have no idea. Even attorneys who don't do this, just not the way to go. There's so many pitfalls. So here's a good one. He brought up a great example. I'm going to put my child, my adult child, on title. And I've seen this over and over. And it's always the son, I'm sorry, but it's the mom who's left behind because dad passed away. And of course she's going to her son. And she puts her son on title. And then son gets in a relationship. Maybe he had it already, maybe it's new. And then she, the new relationship, whether it's wife, girlfriend, or whoever, decides that she wants to live in that house, because why should we live in this apartment when we can live in mom's house? So now mom can live somewhere else. So it's her house for 50 something years. Now she's being put out and having to deal with and having to do legal battle. And at 80 something years old, she's not doing legal battle. So it's a complete nightmare. So if the goal is to transfer title to your child, do that through the trust documents, through that trust process after you're gone and no longer need to live there. It's not a good idea, and I see this every day.
One of the things I want to add too is trying to ensure that your house avoids probate. Depending on the jurisdiction where you live, if you have a transfer on death deed, if you can do a life estate deed, ladybird deeds in Florida. Because one of the things that I see often is where someone doesn't have a lot of money, but they have a house and they go through the probate process. And let's say they had a medical issue before they pass away. And so that deed, this creditor comes forward and they have, this hospital that the bill needs to be paid because the house went through probate. Therefore, the house needs to be sold in order to cover this creditor. So often we take that for granted. So I really want to make sure that we are thoughtful about how do we protect the real property, because indeed, again, that's often the greatest asset that the family has. And as Attorney Usher said, that lawsuit against yourself or against your family in order to pass on those assets. I'm going to
one last thing, Aimee, I want to piggyback on what you're saying is when you do those TOD and ladybird deeds, if you have a mortgage still on the property, the beneficiary will not be able to contact or access that information after your death unless you add them to the account as an authorized representative. So while you're alive, if you're going to do these probate avoidance strategies with your property, just remember that if you have a mortgage and your beneficiary can't qualify on their own financial strength, in some situations, you'll want to make sure you contact that mortgage company, put your beneficiary's name on the deed, because the mortgage company just wants to check when the death occurs, when it's all said and done. But if you want them to be able to call in and see, well, how many more checks do I have to write, or can I pay this off? You don't want them to have to report the death. You want them to just go ahead and be able to identify themselves and then get the information that they need so they can just continue on with that. And then the last thing I would say is, as our community typically does, is we try to just ignore the problem and just leave grandma's name on the property and leave and then pay the mortgage. And then the next thing you know, by the time grandma dies and then you left it then because mom was the oldest and it's supposed to go to the oldest, even though she had 5 other kids. And the law says, well, all the 5 kids get it. And now you have this bickering. And then of course, inevitably some sibling dies. And now you got these nieces and nephews or grandkids that are on the property. So it just explodes. And so this property gets sold because people want to get bought out. And mama's house is only worth $100,000, maybe $50,000, depending on the neighborhood it was in. And so it's very important what Aimee is presenting is clean up the deeds. When somebody dies, clean it up and then put a beneficiary, even if it's one person. We don't care. We just don't want to deal with the bickering and then you end up with a sold house and nobody wins.
And again, that's one of the greatest assets.
Can I jump in on that part, Aimee? Because this is a development. This is about real property. So I need to bring this up, especially in California. So everybody here is freaking out. All this, gentrification is happening in areas where it was always Black. It was View Park. It was Carson. It was all these areas where most of us own our property. And grandma bought that property 50 years ago, or grandma and grandpa, and they bought it for $30,000. And guess what it's worth today? 500,000, $1 million. If you're in Inglewood near SoFi Stadium, that property has increased exponentially. So what happens when you don't have your property in a trust, and it has to go through probate, the probate fees are based on the date of death value of the property. They're not going to go back to the 20 grand that it was paid for. They're going to say, what's it worth today? And then the fees are going to be 20, 30, 50 more thousand. The family left behind, even with a paid off property, does not have the money to pay the fees. They have to sell the property. Guess who's buying the property? The Google guy, the Prime Video guy, the people who have the money who can afford a property at today's current price. And that's why all those neighborhoods are turning over and we cannot afford to live there. So that's another reason why with this real estate, if we want to transfer it, there's a simple way to do it, but you have to get educated and counseled properly and then do it right.
Thank you. These are all such great nuggets, right? And it sounds like it's a follow-up workshop just on that topic alone. So this is all really good. I know we're really close to time. Let's look in the chat and try to get some of these answered. So one says, is there a distinction between a power of attorney and an executor?
Sure. Jennifer, answer that question, please.
Yes. So quickly, I know we're running out of time. So the power of attorney handles while you're living, right? An executor handles the will, the last will and testament meaning after death. They handle the will after the death has occurred. So they can be different people. They don't have to be the same person. A lot of families, they will pick the same person, but when they're operating, they may say, I'm the power of attorney, when really if the death occurred and there's a will and they're the executor under the will, they're operating as the executor under the will once they go to probate, right? Because wills have to go to probate to be effective and, to get your authority to do what you need to do.
Thank you. Thank you. Anyone else want to add, or we'll move to the next question? Does funding the trust mean including your financial accounts, checking, savings, brokerage, IRAs, listed in or under a trust?
Chioma, go for it.
Okay, so when you're funding a trust, you're basically figuring out what is going into the trust. So if it's a bank account, you have to go to the bank and either create a new bank account that's owned by this new trust that you got, or you're also making sure that the account has the trust listed as a beneficiary. Same thing with brokerage accounts, stocks that you may own, obviously real estate, not so much with all the cars, it depends on what kind of car it is, but with individual retirement accounts, the only way really to do that is for the trust to be listed as a beneficiary. So you do have to go through the process of changing the beneficiary on those accounts. And same thing with your life insurance policies. You'd have to change the beneficiary on the life insurance policies. Some trusts can actually own life insurance. So you should talk to your financial advisor and estate planning attorney about how you could do something like that.
Thank you. Jennifer, did you want to add? I saw something popped up in the chat there, or was that to the next question?
That was to the next question.
All right, here it is. Is it wise to have both a will and a trust?
And so I just put in the chat, when you get a trust, so when you get a will-based plan, all of the instructions are embodied in that will. Okay. Now you may have a trust underneath it if you have minor children, but that's for you call us back. Now, if you decide to do a trust-based plan, all of your terms should be embodied in the trust. You get a will, right? Because the trust only controls the terms where the trust name appears, either in the ownership position or in the beneficiary designation if it's life insurance, retirement plans, and annuities. So you still get a will when you get a trust. It's just known as a pour-over will. It says if I forgot anything outside of the trust, without a beneficiary designation and without joint ownership, because if you have a beneficiary or joint ownership, that's a contract. So the minute a death occurs, ownership transfers. So it's no longer in your name if you have a beneficiary or joint ownership. So if you forgot like a stray bank account only in your name, then the will, which only controls things that are left solely in your name, says, go get it and pour it over to my trust where all my instructions are. But remember, as Attorney Deere said, all wills go through probate. So this is why people think, oh, I got a trust, I'm avoid probate. No, trusts can avoid probate. Doesn't mean they will. You have to retitle all of your assets. If you forget to retitle, then we have to use that pour over will to get the asset into the trust, and thus hence why some trusts will go through probate.
The last key point is every estate plan is never a set it and forget it situation. You are always supposed to maintain, update. You sell a property, you gain a property, you get an inheritance, you're a beneficiary on a life insurance policy. All of those things need to be updated. And you find out who your frenemy that you thought was going to be your power of attorney if something happened to you. Those things need to be changed as your life goes on. They are breathing and living things just like you. You have to keep them updated. You shouldn't be walking around with a 20-year.
We control the money. So if your money changes, your rules should change.
Right.
One of the things that I always like to say is I'm a third generation blended family, right? So as we know, the complications of our families, we need to be mindful of what does that look like, because the structure of your family greatly impacts that which you will have.
And then we have one last one. So does the pour over will and trust prevent going to probate? And Jennifer jumped in and said, nope. Pour over will.
If you remember that the will directs the probate process. That's the will directs the probate process. It doesn't do anything else in that. So
That's it for the questions for now. You want to continue
we're
on?
wrapping up 8 o'clock. So it's 8 o'clock. And I wanted to thank the Black Community Developers Group for partnering with the Association of Black Estate Planning Professionals, because we know that we're better together, right? And if we're committed to bridging the racial wealth gap, it's not a matter of what we can do on our own, but it's how we can build our community solidly.
Perfect. Thank you so much, Aimee,
you.
Jennifer, Andrew, Chioma, Gail popped in. We had Charlene. Thank you, thank you, thank you. We will have, and for all of our guests who joined us, we will have a replay available of this workshop with edited questions on the screen and that fancy stuff. So thank you all so much for joining us. Look forward to connecting with you all again, and we'll be sure to include your contact information. So with that said, have a wonderful evening and talk with you all soon.